Breaking news out of Washington state, and gun owners across the country need to pay attention. What looks like an immigration fight on the surface could end up shaping the future of your Second Amendment rights. Here's the deal. The Department of Justice just drew a line in the sand with Washington over their sanctuary policies. They've given the state a hard deadline, and the threat isn't just about losing funding, it's about potential criminal charges against officials who refuse to play ball. Now, you might be thinking, what's that got to do with my guns? The answer is simple. The same legal tactics being used here against immigration sanctuaries could be aimed at Second Amendment sanctuaries next. If Washington gets forced to fold, the playbook will already be written, and your state could be next in line. The roots of this showdown go back to 2019, when Washington lawmakers passed the Keep Washington Working Act. On the surface, it was pitched as a public safety measure. The state legislature, backed by Governor Jay Inslee at the time, argued that local police resources should never be used to enforce federal civil immigration law. The law was sweeping. It told sheriffs and city police departments, no extended detainers. You cannot keep someone locked up beyond their state charges just because ICE asked. No data sharing. Officers and jail officials are prohibited from providing personal information like addresses or release dates to federal agents. No joint operations. Local law enforcement cannot participate in roadblocks or checkpoints intended for immigration enforcement. The intent was clear. Washington wanted a hard firewall between local policing and federal immigration authority. Supporters claimed it would build trust in immigrant communities. They argued that victims and witnesses are far more likely to call 911 if they don't fear deportation. Advocates pointed to examples in sanctuary cities like Los Angeles, Chicago, and San Francisco, where officials said crime reporting among immigrant communities rose once local police stopped working closely with ICE. But here's where the legal tension started building. Under the U.S. Constitution's 10th Amendment, states do have the right to decide how their resources are used. This principle, called the anti-commandeering doctrine, says the federal government cannot force states to carry out federal law. The Supreme Court has upheld that principle in multiple cases, like Prince v. United States, 1997, where the court ruled that the feds couldn't require local sheriffs to perform background checks under the Brady Act. So, in that sense, Washington's law was consistent with precedent. We're not your deputies. We won't enforce your immigration law for you. But here's the catch. The anti-commandeering doctrine only protects refusal to assist. It does not give states the right to actively block federal law enforcement. And that's exactly where Washington drew attention. Critics argued the Keep Washington Working Act didn't just say, "We won't help." Instead, it went further. "We forbid our officers from helping." Period. That subtle difference, refusal versus prohibition, turned out to be the legal tripwire. And this is why lawyers started circling the issue right away. States can say no. They cannot slam the door on cooperation if one of their own sheriffs or deputies chooses to work with the feds. Once you cross that line, you're not just withholding resources, you're obstructing. And in constitutional law, that's a whole different ballgame. From the Department of Justice's perspective, Washington's sanctuary law doesn't stop at refusing to help. It crosses into active obstruction, and that's the line the federal government won't tolerate. Here's the backbone of DOJ's case, 8 U.S.C. Paragraph 13973. This statute says state and local governments cannot prohibit their employees from sharing immigration information with federal officials. In other words, if a sheriff, jailer, or police officer wants to pick up the phone and tell ICE, yes, this person is in custody, here's when they'll be released. The state can't forbid that. Washington's Keep Washington Working Act arguably does exactly that. It tells local agencies not just don't prioritize immigration enforcement, but don't share this info at all. To DOJ lawyers, that looks like a direct violation of federal law. But it gets even sharper. One of the flashpoints that really set off DOJ was when Washington's Attorney General actually sued Adams County Sheriff Dale Wagner for cooperating with ICE. Wagner was voluntarily sharing information with federal authorities. Instead of letting him exercise discretion, the state came down on him like a hammer. For DOJ, that was Exhibit A, proof that Washington wasn't just opting out, it was punishing cooperation. From there, DOJ's argument builds into two main points. Supremacy Clause. Article 6 of the Constitution makes federal law the supreme law of the land. States cannot nullify it, override it, or create legal penalties for those who comply with it. Sanctuary laws that go beyond passive resistance start looking like nullification. Obstruction of federal functions. By suing sheriffs and forbidding communication, DOJ claims Washington is actively interfering with federal immigration enforcement. That, in their words, is not protected by anti-commandeering. That's obstruction. And this is where the stakes shoot up. Because if a court agrees with DOJ, it sets a crystal-clear precedent. States may refuse to participate, but they cannot handcuff their own officers from helping the feds. That principle would apply not just in immigration cases, but also in Second Amendment sanctuary laws. Think about it. Missouri's Second Amendment Preservation Act tried to fine police departments $50,000 if they enforced federal gun laws. Sound familiar? Same playbook, just flipped to the gun rights side. And when DOJ sued Missouri, the courts struck it down, on Supremacy Clause grounds. So, for DOJ, Washington is just another battlefield. The immigration angle is the cover story, but the deeper fight is about federal supremacy versus state autonomy. So what happens if Washington doesn't back down? The DOJ's letter wasn't just a political stunt. It spelled out real, concrete consequences. Let's break those down. 1. Criminal prosecution. The Department of Justice made it clear. Any state or local official who uses their position to block federal immigration enforcement could face federal charges. That includes statutes like harboring illegal aliens, obstruction of federal proceedings, or even conspiracy. We're not just talking about low-level officers. This could extend to sheriffs, mayors, even the governor himself, if DOJ really wanted to press the point. That kind of personal legal risk is a massive pressure tactic. 2. Loss of federal funding. This one hits harder than most people realize. Washington receives millions in federal law enforcement grants every year. Those dollars support everything from police training to equipment and technology. The DOJ is saying flat out, if you don't comply, the money stops. For a state budget, losing that stream isn't just inconvenient, it's crippling. And it's not a new tactic. Under the Trump administration, DOJ tried to cut grants to New York, California, and Chicago over sanctuary policies. Some of those fights went to court, but the point is clear. Washington's money is on the line. 3. Civil penalties and lawsuits. The DOJ is also threatening direct lawsuits against agencies that refuse to share information with federal authorities. If a county jail refuses to cooperate with ICE detainers, DOJ could sue that jail, and federal judges could issue binding orders requiring compliance. That means local sheriffs could end up caught between state law, telling them, don't cooperate, and federal court orders telling them, you must cooperate. That's the exact kind of legal tug-of-war that often leads to big constitutional rulings. And here's the kicker. Every one of these tools could just as easily be pointed at Second Amendment sanctuary states. Imagine a federal assault weapons ban passes. Your state says, we're not enforcing it. DOJ could threaten to indict sheriffs who refuse to carry out the ban, cut federal grants to state police, and sue counties that ignore ATF requests. The playbook is the same. What happens in Washington may very well be the legal test case for how aggressively DOJ can swing the hammer in those future fights. Washington didn't take the DOJ's threats lying down. Governor Bob Ferguson came out swinging, framing the entire fight as a matter of state sovereignty and community safety. His message was blunt. We're not changing our values because of political intimidation from D.C. The state's legal team, led by Attorney General Nick Brown, argues that Washington law has been carefully crafted to avoid direct conflict with federal statutes. Their position is this: the Keep Washington Working Act doesn't block federal agents. It simply says state officers won't spend state resources enforcing federal immigration policy. In their eyes, that distinction keeps the law squarely within the protection of the anti-commandeering doctrine. To bolster their case, Washington points out that federal courts have repeatedly said the government cannot force states to enforce federal law. Cases like Prince v. United States and Murphy v. NCAA affirm that the 10th Amendment prevents the feds from commandeering local resources. Their argument is, look, ICE can still do its job. We're just not going to be their deputies. But here's the sharp edge of the controversy. If that's really all Washington's law did, the DOJ might not be as aggressive. What makes this different is the lawsuit against Sheriff Dale Wagner, who chose to voluntarily cooperate with ICE. By suing Wagner, the state effectively punished an officer for helping federal enforcement. That's the piece DOJ calls unconstitutional. Washington insists the suit was about enforcing consistency across the state, but to federal lawyers, it looks like obstruction. And this is where the case becomes a balancing act. Washington is trying to walk a fine line, asserting their right not to participate, while also discouraging local officials from undermining the state's policy. But legally, once you start punishing cooperation, you're in dangerous territory. That could be the very thing that collapses their defense in court. Now, here's where it connects directly to the firearms community. On the surface, this looks like an immigration case. But the deeper issue is about the balance of power between states and the federal government. And that exact same question sits at the heart of every Second Amendment sanctuary law out there. Look at what's been happening in gun-friendly states. Missouri passed the Second Amendment Preservation Act, which declared certain federal gun laws unenforceable inside the state. They even went so far as to let citizens sue police departments $50,000 if officers enforced those federal laws. That's almost a carbon copy of what Washington did with immigration, using state law to block cooperation. And what happened? The Biden DOJ sued. Federal courts struck Missouri's law down, citing the supremacy clause of the Constitution. The courts made it clear states can refuse to help, but they cannot nullify federal law or punish officers who comply with it. Sound familiar? That's the exact trap Washington is now walking into. Other states, Arizona, Montana, Idaho, Tennessee, Texas, have passed their own versions of Second Amendment sanctuary laws. They tell local police not to enforce certain federal gun restrictions, like magazine bans or proposed assault weapons regulations. On paper, it's the same argument Washington is making about immigration. We won't spend our resources on laws we think are unconstitutional. And here's why every gun owner should be paying attention. If the DOJ wins against Washington, they'll have a powerful precedent in their pocket. The next time Congress passes a federal gun restriction and a pro-2A state says, "We're not enforcing that," DOJ can pull out this case and say, "Look, the court's already ruled. You can't obstruct, you can't punish cooperation, and we can cut your funding if you try." Today, it's immigration policy on the chopping block. Tomorrow, it could be your state's protection against federal gun control. When you zoom out, the Washington case isn't just about immigration or even gun rights. It's about the ongoing chess match between state sovereignty and federal supremacy. And here's where the hypocrisy becomes obvious. On one side, blue states invoke states' rights when it comes to immigration. They argue local police shouldn't be conscripted into federal immigration policy. On the other side, red states invoke states' rights when it comes to firearms, insisting they shouldn't be forced to enforce federal gun control. Both sides use the exact same constitutional logic, just on different issues. Democrats will shout federal supremacy when red states resist gun laws. Republicans will shout federal supremacy when blue states resist immigration laws. And when the roles flip, so do their arguments. That's politics. The courts, however, have tried to draw a consistent line. Under the anti-commandeering doctrine, the federal government cannot force states to enforce federal law. But under the Supremacy Clause, states also cannot nullify federal law, obstruct federal agents, or punish people who cooperate with the feds. The Washington case sits right at that crossroads. If Washington is allowed to punish a sheriff for helping ICE, then pro-2A states could also punish police chiefs for working with ATF. If the DOJ succeeds in forcing Washington to back down, then the same strategy can be applied tomorrow to dismantle Second Amendment sanctuaries. That's why this case matters far beyond Seattle or Spokane. It's not just about one state's immigration policy. It's a test case for the future of state resistance to federal power, whether the issue is immigration, gun control, or anything else. And once the courts set that precedent, it will shape the fights gun owners are facing for years to come. So here's the takeaway. What's happening in Washington isn't just about immigration. It's a stress test for how far states can push back against federal authority. If the DOJ wins this fight, you better believe the same legal arguments will get recycled the next time a state tries to shield its citizens from federal gun control. Today, it's about ICE and sanctuary laws. Tomorrow, it could be about AR bans, magazine limits, or whatever else DC decides to push. And the precedent set here could determine whether your state's Second Amendment sanctuary protections hold water or crumble under federal pressure. That's why gun owners need to keep their eyes on this case. Because the battle over immigration could quietly redraw the battlefield for gun rights in America. Make sure you like, subscribe, and drop a comment down below. Stay sharp.